And the last case on the docket is Hovercraft of South Florida versus Ronald E. Reynolds. And appellant, whenever you're ready. And is 5 minutes okay?
Thank you very much, Your Honor.
Okay, you're welcome.
May it please the court, my name is Mark Schuman, and I represent the appellant in this action. The issue before the court this morning is whether the bright line rule established by the Supreme Court in the Saya case, mandating that a motion for attorney's fees and costs must be filed within 30 days of the judgment. As that holding was refined in the Amorous case, which held that if in fact the underlying judgment already contains a determination of a party's entitlement to fees, then it's not necessary to file that Rule 1.525 motion within 30 days.
Counsel, do you believe that there was, because there was a stipulation pretrial to the court as far as fees, that has any bearing on this, or is just the judge's statement in the final order that the judge reserves jurisdiction with regard to attorney's fees?
Your Honor,
does that sever any significance of the pretrial statement?
I would submit to the court, Your Honor, that the stipulation in this case, which may be found in the record appendix, as it relates to this case, says only, and I quote, "The lease agreement at issue contains a provision for attorney's fees to the prevailing party to be resolved post-judgment." That is the only stipulation that addresses attorney's fees. And I would submit to the court that it is precisely this type of issue that the Saya decision sought to address. Having a stipulation such as this is no different than a party pleading an entitlement to attorney's fees. This doesn't establish any entitlement to attorney's fees.
What about the order? The trial judge did not include the word entitle or finding entitlement to the fees.
That's correct. That's exactly what happened in this case. Repeatedly, Your Honor, there were four plaintiffs, four appellees, as you recall. The same language was used by the lower court in its consolidated final judgment, where the court repeatedly said, in any final judgment for fees, repeated it 3 times with reference to each defendant, each plaintiff, which I suggest to the court a plain reading of that indicates that the court understood that a judgment, if any, for attorney's fees and costs was going to be entered at some later time, and that this consolidated final judgment does not constitute a finding of entitlement to attorney's fees, as was found to be the case in Amorous.
Going back to the stipulation, the pretrial stipulation, you read the paragraph that said the lease agreement at issue contains a provision for attorney's fees to the prevailing party to be resolved post-judgment. But a little further on, it also says, since the slip holders have already prevailed on their claims for wrongful eviction, they are entitled to recover their attorney's fees and costs in addressing these issues.
May I respectfully request that the court direct me to what portion of the pretrial statement that appears in?
I'm looking on page 7 of the answer brief, and it appears to be at page 1735 of the record.
And could the court advise me which answer brief it is, which one of the...
I'm looking at the Khalil's and the Sajo's answer brief.
Thank you, Your Honor. Would the court again direct my attention at page 17 to where that language appears?
Page 7.
I beg your pardon. Your Honor, these were identified as issues at trial. They are not stipulations between the parties. I think that it would be a very, very unfortunate precedent to start elevating items that are identified as issues for trial to the level of stipulations that might be binding on the parties and the court. I respectfully submit, Your Honor, that if in fact the court in its consolidated final judgment did not make specific reference to any stipulation, even though there was none here, as I've read to the court from the pretrial statement, then that stipulation, if it was entered into between the parties, has no bearing on the judgment. Otherwise, as we argued in our brief, this would require a reviewing court to go through all of the pre-judgment pretrial stipulations, pretrial statements, and matters of that nature to determine what is being appealed. And I would respectfully submit there would be a horrible, horrible situation to place any reviewing court in, to have to dig through the record in the case to find out what the judge is going to rule. Your Honor, the judgment is very lengthy, and I mentioned that for some reason which I can't explain, approximately 7 or 8 pages were not included, even though the numbers were included. The judgment as it appears in our record appendix was correct, just the pagination is incorrect. The judgment is very, very lengthy. If the circuit court judge was relying upon any item in the pretrial statement, then that item would have been included and should have been included in the judgment. And if the appellees, in this case, did not see such an item included in the final judgment, then they should have brought a motion to amend the judgment to include that item. But there is no question that in this consolidated final judgment, there is no reference to the courts either relying upon or accepting or incorporating into the final judgment any stipulation. And again, I respectfully suggest to the court that what the court read to me appearing at page 7 of the answer brief is only an issue of trial. And
well, it looks like, I mean, in fairness, that clause has a subparagraph 1 and a subparagraph 2. And it says in 1, since the slip holders have already prevailed on their claims for wrongful eviction, they are entitled to recover their attorney's fees and costs to be addressed post-trial. But in sub 2, it says all other claims will be resolved post-judgment depending on who the prevailing party is. So it looks like part of that was stipulated to, the claims for wrongful eviction, with everything else being up for grabs as to who the prevailing party was.
Your Honor, I would respectfully submit that, again, those are items that the parties agreed were going to be issues at trial. They are not stipulations. And when the court looks at the pretrial statement, which was included in our record appendix, the court will see that there are specific delineations between the sections which are addressed in the pretrial statement, and there's a stipulation section and an issues at trial. And respectfully submit that it would not be appropriate to include issues at trial or have them considered as stipulations. Your Honor, the matter concerns me that, again, and at the risk of being repetitive, to have the parties at some point during the course of the litigation, and this litigation, as the court recognizes, extended over years, to have the court elevate what might appear in some of those pleadings to stipulations or to be included in the final judgment, even though there's no reference to it, really would be no different than a party saying, well, gee, because I mentioned an entitlement to legal fees and costs in my initial pleading, I'm entitled to them, because that's exactly what the Supreme Court said. We are no longer, and this court, by the way, in several of its decisions on this issue, that allegation in the pleadings is insufficient, and it must be followed specifically by a motion under 1.525, which is unnecessary if the judgment itself contains an award of attorney's fees and costs.
Well, let me ask you specifically about that 30-day requirement. Let's say that they are bound by the 30-day requirement on moving for attorney's fees, and they are outside of that 30-day requirement. Here, the judge allowed them to file the motion late. And why wouldn't the judge have the discretion to do that under 1.090B?
I think, Your Honor, that it's a matter of substantial fairness. There would be nothing to prevent every party that fails to file the motion within 30 days to attempt to remedy it by filing a motion for late filing. That is not the objective that the Supreme Court sought to achieve by saying it's 30 days. And there has been no decision that I have read that says, but that can be extended. I don't even know, by the way, and I can't state a position, whether that 30-day period may be extended by the parties.
Well, it says in 1.090, it says enlargement of time. When an act is required or allowed to be done at or within a specified time, by order of court, by these rules, or by notice given thereunder for cause shown, the court at any time in its discretion can, one, with or without notice, may order the period enlarged if the request is made before the expiration of the period, so we know we don't have that here, or two, upon motion made and notice after the expiration of the specified period, may permit it to be done when failure to act was the result of excusable neglect.
And that's, I'm glad the court, and I thank you for reading that to me. Your Honor, there was no excusable neglect here. And how do we know that? We know that excusable neglect has been defined by the courts as a situation where a party was precluded from performing some act timely by virtue of a breakdown in the operations of his or her office practice, the computers failed, something happened. In this case, Your Honor, the parties knew that they had to file the motion within 30 days. They knew it because they did, in fact, file a motion within 30 days, but it was after the time elapsed because they had apparently formed the erroneous conclusion that because the appellant had filed a motion for rehearing, that told the 30-day period. So we would submit that a misunderstanding of the law, which we would submit as what happened here, does not constitute excusable neglect that would entitle the circuit court almost 3 years after the fact to allow the late filing of this document. Your Honor, it's important that if a court is going to, as the Supreme Court did, to establish a bright line rule so that parties don't continually appear before the courts of appeal trying to remedy these things, that these bright line rules be upheld. One of the issues that concerns me, Your Honor, is that a fair reading, the language that is included in the consolidated final judgment does not talk about any entitlement of the appellees to legal fees. In fact, the motions themselves that were filed by the appellees acknowledge that by asking for a judgment for attorneys' fees and costs. If the appellees believed the consolidated final judgment constituted that, then they wouldn't have, both of them would not have entitled their motion request for final judgment on attorney's fees. They would have limited solely to a determination of attorney's fees. Your Honor, we would respectfully submit, and I want to reserve a little bit of time, that in this instance, the fact that the appellees filed their motions for attorney's fees within 30 days after the denial of our motion for rehearing clearly shows that the appellees understood the obligation to file the 30-day requirement, 30 days, to file the motion within 30 days, but erroneously concluded that the filing of the motion for rehearing told that 30-day period from running, and that therefore their motions for attorney's fees were untimely, and that they therefore are not entitled to any attorney's fees. Are there any further questions before I retire?
No.
Thank you.
Thank you.
Good morning, Your Honor.
Good morning.
Your Honors, my name is James Beadle, and I'm just preliminary advising the court that co-counsel who is representing the Fischers and Reynolds and I agreed to split our time. So I'm going to be addressing primarily issues that have to do with my clients, because there are some unique issues that apply to my clients as opposed to Ms. Olney's clients. And I will address those first and make some comments regarding some of the questions the court asked as well. I'm sure Ms. Olney will do the same.
And we'll rely upon you all to figure out how much time you want for each.
We're going to split it evenly, or as evenly as possible.
Could you address the excusable neglect argument?
Yes, Your Honor. Basically, counsel stated part of the rule. It says, as well as intervening circumstances beyond the party's control is also part of the rule. And it's this is the Bodette case, which is cited in the brief. It also states that in essence, the excusable neglect is in essence an equitable one, which should take into account all the relevant circumstances, including prejudice to the other party, the reason for the delay, the duration of the delay, and whether the movement acted in good faith. In support of our motion, which was verified, essentially what we asserted in this motion is that the course of conduct between counsel during the entire time of this litigation, other than the very first issue that came up, which related to an interlocutory order regarding possession, which is one of the issues that applies to my client, the Khalils, the parties never held themselves to, or rarely ever did, unless somebody said something, to timelines. Also, as asserted in the motion, counsel for HOVERCRAFT and counsel for the movements had various conversations, both pre-trial and post-trial, involving the fact that the movements were prevailing parties and were entitled to fees and costs. In fact, post-trial, Hovercraft's counsel and the undersigned spoke several times in an attempt to limit certain issues to be addressed at the attorney's fees and costs hearing. At no time during those conversations did counsel for Hovercraft ever advise the undersigned the course of conduct or dealing between the parties had changed regarding these timelines. In reliance upon that conduct, the undersigned did not believe it was necessary to comply with the 30-day time requirement, for both the course of conduct and the fact that there was an acknowledgement that we were in fact were the prevailing parties throughout the litigation. The issue about waiting 3 years, quote unquote, to file the motion to extend time, we never knew that it was an issue until we were literally setting the hearing for the attorney's fee hearing. It was only at that time that the motion for extension of time got filed, because we never knew there was an issue until then. So that was in fact timely in that context.
Well, why wouldn't you know that it's an issue?
Because...
Is there a mistake in law that you...
No, because we've never had any issues regarding timelines or prevailing parties. I mean, counsel for the appellant acknowledged during this entire proceeding that we were prevailing parties. If we're prevailing parties, why would we need to worry about that?
Well,
I mean, there's agreements of parties. We have stipulations throughout, you know, the pretrial statement as recited indicated that we're prevailing parties. Why, you know, and the court took into account its prior rulings. It took into account that the matters that were set forth in the pretrial.
Just because you're the prevailing party doesn't mean that you're entitled to your attorney's fees.
Where there's a contract, the Conway case that I cited, if you're the prevailing party and there's a contract that says a prevailing party is entitled, then you're entitled to attorney's fees at that point.
Well, the court always makes a determination whether they're on the record, whether there's an entitlement to attorney's fees, correct?
It basically did by saying that all it's going to do is determine what the attorney's fees are. There's nothing on the face of...
There's a difference between saying what the attorney's fees are and the first step, which is a party is entitled to attorney's fees. It's a two-step process, correct?
I think the only way I can really answer that, and I'm not trying to avoid the question, is that if there is a contract that provides for prevailing parties, essentially the court has no discretion not to award attorney's fees. That person's entitled to attorney's fees as the prevailing party. Going through the final judgment, to use that as the base document, there is not one issue that appellant prevailed on in this case. The final judgment says go hence without day as to any of their claims, and as to every contested issue in this litigation, the appellant prevailed on none of them.
But nothing in the final judgment said that your clients were entitled to attorney's fees. There was just a reservation of jurisdiction to determine at the end, correct?
There's nothing in the final judgment. There is in the pre-trial statement, and the court
Well, that's
basically
not what
says that it's dispositive.
But the final judgment is what we're looking at, and the final judgment just says I reserve on, well, the basic reservation language at the end. It doesn't say that, I didn't see where it said in the final judgment that the parties were entitled to attorney's fees. It just says the court reserves jurisdiction to determine attorney's fees and costs.
After it recited that we prevailed on every issue in the case.
Well, could you not prevail on a claim for breach of contract that has an attorney's fee provision and still not be entitled to the fees because the other party, say, served a proposal for settlement that you didn't beat by the appropriate amount?
Okay.
You get a nominal judgment, maybe that technically makes you the prevailing party.
I guess the question
And I
is,
guess
are
at
there
that
some
point,
instances-
but again, at that point, we would be entitled to fees, and the court would have to determine what the amount of the fees are. Whether we're entitled to a nominal amount of fees. I mean, but the point is that we have prevailed, and as a prevailing party, we're entitled to fees based on the cases that are cited in our answer brief. And again, part of the issue in this case has been that the course of conduct between the parties is part of what the background is for this case. And also the trial court, when the court went through the judgment, or included in the judgment are the recitations of the findings of fact that the the best way to say this, that, again, I don't mean to be repetitive, but that all of the appellees prevailed on all of their claims against the plaintiff. And in this case, there was no offer of judgment to address that issue.
But you would concede that the final judgment doesn't say you're entitled to fees. It says we reserve jurisdiction to determine attorney's fees and costs.
I would disagree with that in the context of how the balance of the judgment is written, and Ms.
Well, will
Longley.
you point me to in the judgment?
Okay. Well, it does not specifically state that. I agree with that.
How do you square that with the Saya Motor Freight Line versus Reed case, where the Florida Supreme Court said that rule?
I suppose in part it has to go to the fact, which is one of the issues that we raised in our brief, is that to, in essence, follow that case blindly, so to speak, which is what appellants wish for the court to do, that it ignores the agreements that were ongoing between the parties throughout the litigation about how certain matters would be handled. And the cases that were also cited regarding stipulations and agreements between the parties have the right to rely on each other during the course of the litigation. And for the rules of the game, so to speak, to suddenly change just because a final judgment's entered.
Was there a stipulation, a pretrial stipulation that had the magic words that says we stipulate that the parties are entitled to fees, or was it just the issues to be tried fees?
Well, the issues to be tried as far as fees are concerned acknowledge and recognize that we are the prevailing parties and we're entitled to fees. If those are...
But if that's an issue to be tried, I mean, this is the reason why you have stipulations, that issues that don't need to be addressed, and then you have issues to be tried that are issues that need to be addressed and resolved during the course of the trial. So unless it's something, there's a stipulation that says the party is parties are entitled to fees, I don't see how you can turn an issue into a stipulation.
Well, the pre-trial sets forth what the issues at trial are supposed to be. The issues that are agreed to are no longer issues for the trial. That's essentially what the cases are that are cited in the Khalil's and Seho's brief.
And counsel, you have about 9.5 minutes left.
Okay, then I will defer to counsel. I'm sorry I didn't get the chance to answer the question.
May it please the court, my name is Patricia Olney. I represent Ron Reynolds and the estate of Joseph Fisher, which is substituted for Eleanor and Joseph Fisher. I'd like to begin by pointing to something that Judge Orfinger raised, where I disagree with Mr. Schuman. If you look at the consolidated final judgment on the very first substantive page, which would be page 2, as it was originally numbered, and there was a glitch in the numbering when computer elements were merged. But he says under item 1, he says, the court came to be heard, the court having considered the evidence presented by the parties at trial, the prior rulings by the court, the stipulations of the parties set forth in the joint pretrial statement on consolidated actions dated November 24, 2009, the written closings, etc. So he does reference this very document, the joint pretrial statement. And keep in mind, you have factual stipulations in a joint pretrial statement, but you also have the agreement of the parties. When we put our signatures on the end of this, this means that objections to exhibits that aren't raised or waived. There are all sorts of things that go beyond factual statements, factual stipulations when you have a joint pretrial statement. This was not a unilateral pretrial statement, as you sometimes have when people don't get together on this. And as Judge Orfinger pointed out, it's stated very clearly and very specifically in the issues for trial, because partial summary judgments have already been granted for all the slip holders on wrongful eviction. And all that's left is damages and resolving the declaratory judgment actions. And the court, and it's actually on page 14 of the joint pretrial statement, when the court said, the parties agreed on the claims for attorney's fees, since the slip holders have already prevailed on their claims for wrongful eviction from their slips, they are entitled to recover their attorney's fees and costs incurred in addressing these issues to resolve post-trial.
But nothing then, it says, you know, the trial judge has considered these things, and the trial judge is now making the following findings, and there was no finding by the trial court in the order that said that your clients were entitled to fees. There was just the reservation at the end. So if we just go to the reservation at the end, we have to go to the Saya case, and the Saya case says that a final judgment that reserved jurisdiction to award attorney's fees does not take it out of the rule requiring that the motion for attorney's fees be filed within 30 days. And so that doesn't necessarily mean that you can't get it and can't file it late, because 1.090 does allow that, but only allows it in certain circumstances. And so then the same question is, where is the excusable neglect? Because honestly, I believe we're required to follow this case. It's a Florida Supreme Court case. It says when it just reserves jurisdiction and the final judgment, then you've got to comply with the 30-day rule.
But there is
comply with the 30-day rule.
There is much more language in the consolidated judgment about fee judgments. If you look at, I believe if you look at page 6 of the judgment, and this appears for each of the slip holders, where it talks about Ron Reynolds shall recover, let me see if I've got the right page. And this is adjudged as follows, section, paragraph 3, shall recover from Hovercraft, and then it goes on to address how the fee judgment and the consolidated final judgment are going to be paid. And it says that any charges that accrue to Hovercraft under the lease after entry of the final judgment shall be credited against this judgment amount, and any judgment for attorney's fees Reynolds may obtain subsequent to the final judgment. Such credits for payment shall be first chargeable against the interest under the final judgment and any attorney's fee judgment for Reynolds, and then to principal under the final judgment and any attorney's fee final judgment. It doesn't say any attorney's fee judgment, if any, and that's how Mr. Schuman would like to rewrite it, and quite frankly...
It also doesn't say you're entitled to attorney's fees, and so there's a level of ambiguity in there.
Well, in the reservation, it says reserves jurisdiction to determine attorney's fees and cost. It doesn't say to determine entitlement to attorney's fees and cost. You know, when I think that language, and this is how Judge Maxwell understood it, applying the Amaris decision well down the road, was that, and if you look at his order, if I can get to the right place, he actually says that the consolidated judgment and this was the order that was entered. It was a hearing March 14th, 2013, and an order entered that September. He says he found, after considering all of this, that the consolidated final judgment determined that they were the prevailing parties and that they were entitled to attorney's fees and costs. As such, he applied Amaris to it. Then in the alternative, he felt that there was excusable neglect. The excusable neglect comes from the fact that, you know, after, you have to have, even when you've got entitlement to attorney's fees, you have to have some sort of trigger to get you before the JA to get time set for an evidentiary hearing. So this is what our motions filed once the rehearing was said and done. And quite frankly, at a time when you feel a little bit more comfortable about the other side seeing your fee bills than you do when you're still in the depths of litigation.
Regardless, though, it doesn't toll it. The motion for hearing doesn't toll it.
No,
It's
it
required
doesn't.
for the 30 days.
No, it doesn't toll, but his speculation that that's because we misunderstood it is just flat wrong and speculation.
You
It
just
was
didn't, why didn't you file it then within 30 days from the judgment?
because we already had a ruling on entitlement. And all we had to do now is reduce it to judgment and discuss the amounts. And further on that is the fact that in that interim period, we all stipulated to what the reasonable hourly rates were for me and Mr. Beadle. Now, if there was no entitlement, why would Mr. Schuman be stipulating to our hourly rates if this wasn't clearly
It's not
understood?
entitlement, it's what triggers the statute. What triggers the rule that requires you to file your motion in time? I don't think there's saying that, perhaps you weren't entitled to it, but that the final judgment doesn't say that. You're required, they're holding you to the rule. And the rule says 30 days, and you didn't file it within 30 days, and so I don't think there's, probably isn't an argument whether or not you're entitled. The argument is whether or not you got to the courthouse in time.
Well, I think the argument is really whether or not Judge Maxwell was wrong when he decided at the hearing in March 2013 that the original consolidated final judgment had found us entitled to attorney's fees, and it only left the issue of how much are those attorney's fees. And that was reflected in a stipulation for hourly rates, which would be premature otherwise. And the fact that this whole, I'm challenging your entitlement to it, didn't come up until January 8th of 2013, when we were trying to set this for an evidentiary hearing on the amount of attorney's fees.
But it come up, and what did they argue? They argued that you didn't file it in time?
In January 8th, 2013, they let us know for the first time, I believe it was an email that is in the record, that said, oh, we don't think you're entitled to attorney's fees now because you didn't file within the 30-day time period.
Well,
That
when
this
would they-
judgment didn't award you attorney's
When would they do
fees.
that? When would they make that objection?
Well, I think they could have made it at some time between the November, December 2010 motions and waiting until 2013.
They could have, or they
I
could
mean-
have just waited until the time it was filed.
Until the time it had already been filed.
At the time it was set for hearing.
I think they needed to give some objection if we were going forward with that. And what it actually shows, Your Honor, is that there was no surprise here, and that's what Ameris and those decisions are trying to protect against, is unfair surprise.
what's
They
the
knew the
purpose of the rule?
entitlement was
Then what's the
resolved.
purpose of the rule? What's the purpose of having a rule that says you have to file your motion within 30 days if it's ultimately meaningless?
It's not ultimately meaningless, but in the language of our consolidated final judgment, the reasonable way to read this is the way Judge Maxwell read it, which was that this found entitlement, leaving only the determination of the amounts of attorney's fees. Like I say, this could have been written to say, here's how you're going to apply payments to attorney's fee judgments, if any. It didn't say that.
Who did the final, did he write the final judgment, or was the final judgment?
It was a combined final judgment by all of us. Mr. Beadle and I worked on it initially. It went past Mr. Schuman for his comments and remarks, and then it went to Judge Wone for his final decision. He actually had sent us a letter that had his rulings set forth in it. We had a hearing that sought some clarification there. But, I think it's very unusual to see a judgment that spells out how these payments are going to be applied and how credits are going to be applied, and that speaks in terms of any fee judgments that you're going to get. I mean, you could have multiple fee judgments, and that may in fact occur.
But you're reading that to assume that because it doesn't say, and attorney's fee judgments, if any, you're ascribing a different meaning to that than, and any attorney's fee.
Yes, sir,
Because it doesn't, the use of any doesn't mean it's inevitable.
well, we could have settled the attorney's fees and not ended up having judgments. But it doesn't leave any doubt that there will be attorney's fee judgments out there. And then when you come back, and the clauses do not say, the court reserves jurisdiction to determine entitlement to attorney's fees. If it had said that, then yes, you'd have to have the motions within 30 days. But it did not. It says reserves jurisdiction to determine attorney's fees and costs and to award Reynolds additional damages for each month Reynolds is denied possession of a slip after entry of his final judgment. So you're talking about reducing things to dollars at that point in time. And under the circumstances, I think Judge Maxwell's ruling was correct, and there's no basis for overturning it, particularly considering that the parties acted for over 2 years on the understanding that attorney's fees had already been resolved, as
Thank you, you're out of time, Counsel.
the pretrial statement reflected they had been too. Thank you, Your Honors, and thank you for letting me run a little over.
About 3.5 minutes.
Thank you very much, Your Honor. Your Honors, I respectfully direct the court's attention to the consolidated final judgment, pardon me, and specifically pages 6, 11, 16, and 32, because on each of those pages, and we'll go back to page 6, the same language is utilized by the court, referring to any judgment for attorney fees Reynolds may obtain subsequent to this final judgment. And again, it says, any attorney's fees judgment in favor of Reynolds, and a third time, any attorney fees final judgment. It says that same 3 repetitive phrases in each of the last paragraphs for the 4 appellees. I'm very concerned by the attempt to, I perceive it as an attempt to equate collegiality between the parties as an effort to, as engaging in sharp practice. The fact of the matter is, all counsel acted collegially and professionally vis-a-vis each other. Despite the fact that counsel says that I didn't object to the late filing of the motion for attorney's fees, they still filed it without hearing from me in any respect. Even if I had objected when they filed the motion 4 months later, after it was due, it wouldn't have done them any good. They couldn't have repaired their error. My brother also says that there was a course of conduct, so there was no need to rely on timelines. Well, I would agree to the extent that we extended each other professional courtesies regarding responding to, providing answers to interrogatories, responses to requests for documents. But my brother does not say, because he can't say, that he ever discussed with me at any time the need to file a motion pursuant to Rule 1.525, and that I responded in any way that induced him not to file one, because we never discussed Rule 1.525 prior to 2013. By that time, it was several years too late. So that the fact of this collegiality does not indicate, and my brother does not assert, he didn't assert orally before you or in his brief, that any statement was ever made by me concerning that issue. Thank you very much for your consideration.
Thank you. And we are in recess.